Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Hello, and welcome to the Arbitration World podcast. This mini-series will focus on key cases and trends in the U.S. that have had an impact on international arbitration, both within the United States and abroad. My name is Lindsay Bishop, and I am an international arbitration and commercial disputes partner in the Boston office of K&L Gates. Joining me on the podcast today are my colleagues, Carolyn Branthoover, Jackie Celender, and John Gavin. Carolyn and Jackie are partners in K&L Gates' Pittsburgh office and members of the International Arbitration Practice Group. John is an associate in our firm's Boston office and has experience in international arbitration as well. On this episode, we will discuss the oral argument heard by the Supreme Court on March 23rd in two cases, ZF Auto, U.S. versus Luxshare Limited, and Alex Partners versus the Fund for Protection of Investment Rights in Foreign States, both dealing with the scope of discovery available through U.S. courts and assistance to foreign arbitrations. We'll begin this episode by summarizing the state of the law leading up to the Supreme Court's consideration of ZF Auto and Alex Partners, including a circuit split on the issue, and then get into oral arguments and potential implications of the court's upcoming decision. Before we get too far, I'd like to mention that my colleagues recently co-authored an article on these oral arguments entitled U.S. Supreme Court Hears Oral Argument on Circuit Split over Scope of 28 U.S.C. Section 1782 for Obtaining Discovery in International Arbitrations. You can find this article, along with more international arbitration content, on the Thought Leadership section of the International Arbitration Practice Group page on our firm's website, which is www.klgates.com. With that out of the way, we can start digging into the topic of today's episode. Central issues in the cases before the Supreme Court is whether litigants in foreign private arbitrations can come to U.S. courts for discovery assistance under a federal statute, 28 U.S.C. Section 1782. By way of background, there is a circuit split on the issue of whether such discovery assistance is available. John, would you like to walk us through the statute and the state of the law up to the circuit split?
Certainly, Lindsay. It's great to join you today. The current version of Section 1782 was enacted by Congress in 1964 and built upon prior statutes that provided for discovery assistance in the United States for foreign proceedings. Prior to the 1964 amendment, that discovery assistance was limited to proceedings in courts in a foreign country. In 1964, Congress changed that language to allow discovery assistance in proceedings before any foreign or international tribunal. Prior to the cases currently before the Supreme Court, the court had examined Section 1782 only once, in a 2004 decision known as Intel Corp v. Advanced Micro Devices, Inc. In that decision, the court held that the Directorate General for Competition of the Commission of the European Communities, essentially the EU equivalent of the Federal Trade Commission, was a foreign or international tribunal under Section 1782, and that parties before that body could seek discovery assistance under Section 1782. However, left unanswered by Intel was whether a private arbitration is a foreign or international tribunal under Section 1782. That is the issue on which circuit courts have diverged and out of which ZF Auto and Alex Partners arise.
Thanks very much for that background, John. As you noted, the circuits are currently split on the application of Section 1782 to private commercial arbitrations, with two circuits holding discovery assistance is available in private arbitrations and three circuits holding it is not. Jackie, could you walk us through the circuit split on this issue?
Yeah, absolutely, Lindsay. Happy to talk some more about that. The Fourth and Sixth Circuits have previously held that private arbitrations are foreign or international tribunals under Section 1782. Those courts base their decisions on their definition of the word tribunal, which they reasoned encompassed more than just state-sponsored bodies. They also noted that a prior version of the statute had been limited to courts in a foreign country, and that the broader statutory language was meant to capture private arbitral bodies. On the other side of the coin, the Second, Fifth, and Seventh Circuits have held that private arbitrations are not foreign or international tribunals under Section 1782. The Second and Fifth Circuits decisions relied on pre-Intel decisions and concluded that the analysis of whether Section 1782 applies to disputes before private arbitral tribunals was unchanged by Intel. The Seventh Circuit, on the other hand, engaged in a detailed analysis of the statute and concluded that a foreign or international tribunal is limited to state-sponsored, public, or quasi-governmental tribunals. It's also important to note that two circuits, the Third and Ninth Circuits, have cases pending on this issue currently.
And what are the practical implications of that circuit split? What does it mean in the real world?
Yeah, it presents a host of issues for U.S. entities that may be subject to applications for discovery under Section 1782. It essentially means that whether an entity can be forced to provide discovery to a foreign private arbitration may depend entirely on where that entity is located in the United States. For example, in Servotronics v. Boeing, the Fourth Circuit allowed Servotronics to take depositions of U.S. citizens using Section 1782. Meanwhile, in Servotronics v. Rolls-Royce, the Seventh Circuit held that Servotronics was not entitled to the production of documents by a U.S. entity. These two cases arose out of the same foreign arbitration, and there were drastically different outcomes based on the fact that one discovery target was in Illinois and the other in South Carolina.
And if I could just add to Jackie's point there, the split also presents an issue for litigants in foreign arbitrations, allowing discovery in the U.S. from some third parties and not others. And that issue is further compounded when U.S. entities are engaged in those arbitrations. For example, a U.S. entity based in South Carolina could be required to produce discovery as a third party for use in a foreign arbitration, but would be prevented from taking discovery from a third party based in Illinois in its own foreign proceeding. It presents the potential for real unfairness to the parties involved in foreign arbitrations.
Thank you both for that summary of the law and the concerns arising out of the circuit split. Now, I'd like to dive into the two cases before the Supreme Court, ZF Auto and Alex Partners. Starting with Alex Partners, John, how did that case arise and make its way to the Supreme Court?
Sure, Lindsay. Alex Partners began in the Southern District of New York, where a Russian entity sought discovery from a U.S. entity for use in an investment treaty arbitration against Lithuania. Despite Second Circuit precedent that private arbitrations are not foreign or international tribunals, the court allowed that discovery. The Second Circuit affirmed, drawing a distinction between private arbitrations and investment treaty arbitrations.
And what about ZF Auto?
ZF Auto began in the Eastern District of Michigan, where a Section 1782 application was filed to obtain discovery for use in a commercial arbitration in Germany. Applying Sixth Circuit precedent, the court allowed the application. From there, ZF Auto took a bit of an unusual route to the Supreme Court. The petitioners sought a writ of certiorari before judgment, bypassing the Sixth Circuit and taking the case straight from the Eastern District of Michigan to the U.S. Supreme Court.
Jumping into the oral arguments, Carolyn, it seems like the Supreme Court had a lot to tackle here. We have two different cases seemingly arising out of different facts. One, a private arbitration, the other, an investment treaty arbitration, and some pretty complex statutory interpretation. How did the parties address those issues?
You're right, Lindsay, there was a bit to unpack. The court heard about 2 hours of argument from the petitioners, then the Solicitor General's office, which was also participating, and then the two respondents, and finally rebuttal by the petitioners. The petitioner's argument focused on drawing the line as to how far Congress intended to broaden the discovery assistance available under 1782 when it selected the phrase foreign or international tribunal. Both of the petitioners and the Solicitor General's office argued that a foreign or international tribunal is limited to bodies created and empowered by a sovereign. This argument was based on their further argument that foreign has a governmental connotation as used in phrases like foreign flag and foreign leader. Without that limitation, the petitioners argued Section 1782 could be applied in any number of situations And one of the petitioners even suggested that the German equivalent of a Judge Judy would be a foreign or international tribunal under the respondent's definition. The Solicitor General's office also argued that a broad interpretation of Section 1782 would not support the comity goals of the United States and would flood U.S. courts with discovery applications. Bear in mind that the targets of a Section 1782 subpoena are typically parties not involved as a party to the foreign arbitration proceeding, and that Section 1782 affords discovery to parties in foreign proceedings that is unavailable to parties involved in U.S.-seated proceedings. On the other side, the respondents argued that private arbitral tribunals in foreign countries are foreign or international tribunals by definition because they're empowered to make final decisions on the merits and they're seated in a foreign country. The respondents also argued that Section 1782 was meant to encompass private arbitral tribunals because those bodies existed at the time of the statute's enactment, and the statute does not clearly limit its application to government bodies. Finally, the respondents noted that to the extent parties wanted to avoid U.S. discovery through Section 1782, they could easily agree to do so in the scope of their arbitration agreements.
And how did the justices react to those arguments? Any points that they appeared to focus on?
Well, the parties certainly had a hot bench, and the justices' questions were wide-ranging and focused on a number of issues. In particular, the justices seemed to focus on whether the word foreign had a strictly governmental connotation, as Carolyn mentioned, the petitioners argued, whether there was a significant difference between the private arbitration in ZF Auto and the investor state arbitration in Alex Partners, why the Solicitor General's office opposed discovery in Alex Partners, and why the scope of Section 1782 was not a political question the court should leave to Congress.
Thank you, Carolyn and John. It will certainly be interesting to see how the Supreme Court resolves these issues when it publishes its decision, which we can expect by the end of summer 2022. On that note, Jackie, any potential implications to note of the Supreme Court resolving this issue one way or the other?
Yeah, absolutely. A decision on this issue has the potential to have a major impact on the traditional benefits of private international arbitration. If the Supreme Court holds that private international arbitrations are covered by Section 1782, parties to such arbitrations will have a powerful tool for obtaining discovery across the United States and will not be limited to pursuing the discovery only in district courts within the Fourth and Sixth Circuits. If the Supreme Court adopts the narrow interpretation of Section 1782, U.S. entities will be insulated from discovery obligations in aid of foreign arbitrations, and litigants in those arbitrations may be foreclosed from that meaningful discovery. Now, it's also possible the court may adopt the middle ground and endorse the Second Circuit's latest position that investment treaty arbitrations are covered by Section 1782, but private arbitrations are not. This mixed result might move investment treaty arbitrations over the line, so to speak, while leaving private party arbitrations behind it, but it may not fully resolve where that line is to be drawn. We'll have to wait and see.
Thank you, Carolyn, Jackie, and John, and thanks to you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks. That's HUB Talks in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.